Supreme Court, while releasing an appellant in cryptocurrency case on bail, imposed the condition to deposit an amount of 35 lakh with the trial court within a period of 6 months from today, or the bail will be cancelled. Court further added that we are conscious of the fact that we have been condemning the high courts when they impose such conditions, but here is a case wherein we are compelled to impose such conditions having regard to peculiar facts of the case. The offense related to cryptocurrency and the amount involved, according to the investigating officer, was approximately 4 crores. Undoubtedly, Supreme Court said that it is an economic offense. We do not undermine the seriousness of the alleged crime. Unfortunately, almost 2,000 investors have lost their money in the scheme floated by the appellant along with the co-accused. The trial is going on in the Court of Chief Judicial Magistrate, Raipur. Till date, one witness has been examined. We are informed that the first informant has entered the box and recording of his oral evidence is going on. The problem is that the prosecution intends to examine 189 witnesses. Again, a big question, who are these 189 witnesses and why the public prosecutor intends to examine so many witnesses? Court took notice of the fact that since the trial is being conducted by Chief Judicial Magistrate, the maximum punishment he can impose if the offence is established would be 7 years. The court said that there are several issues, whether the reasons for being unable to conclude trial within 60 days from the first date fixed for taking evidence are attributable to the accused, whether there are any chances that the accused tampering with evidence or causing prejudice to the case of the prosecution in any other manner, whether there are any chances of abscondence of the accused on being bailed out, whether accused was not in custody during the whole of the said period. It would also be relevant to take into consideration the punishment prescribed for the offence for which the accused is being tried in comparison to the time that the trial is likely to take, regard being had to the factors like volume of evidence, number of witnesses, workload on the court, availability of prosecutor, number of accused being tried with accused, and their availability for trial, etc. This court is of the view that the factors, parameters, circumstances, and grounds for seeking bail by the accused, as well as grounds to be considered by the magistrate for his satisfaction, would not exactly be same, but they may in a fact situation be relevant and overlap with each other in both the situations. The court is of a considered view that the applications under section 437(6) have to be given a liberal approach, and it would be a sound and judicious exercise of discretion in favor of the accused by the court concerned, more particularly where there is no chance of tampering of evidence. Example, where the case depends on documentary evidence which is already collected, where there is no fault on the part of the accused in causing of delay, where there are no chances of any abscondence by the accused, where there is little scope for conclusion of trial in near future, where the period for which accused has been in jail is substantial in comparison to the sentence prescribed for the offence for which he is tried. Normal parameters for deciding bail applications would also be relevant while deciding application under 437(6) of the court, but not with that rigor as they might have been at the time of application for regular bail. Where there is absence of positive factors going against the accused showing possibility of prejudice to prosecution or accused being responsible for delay in trial, application under section 437(6) has to be dealt with liberal hands to protect individual liberty as envisaged under the Constitution of India and sought to be protected by insertion of subsection 6 to section 437 of the code by the legislator. Court referred to the case of Nehul Prakash Bhai Shah versus State of Gujarat, where subsection 6 of section 437 has been exhaustively explained by the High Court of Gujarat. The magistrate is obliged to make all possible endeavors to see the provisions contained in 437(6) of the code are complied with in true letter and spirit. To that extent, it appears that a right accrues in favor of the accused to tell the court concerned that the trial has not been concluded within 60 days from the first date fixed for taking evidence for no fault on his part, and therefore he should be released on bail. Maybe at that stage there is some discretion vested in the magistrate to refuse bail, but for the reasons which the magistrate may deem fit to record. So far as fundamental rights of the accused envisaged under Article 21 of the Constitution of India is concerned, it relates to speedy trial. The same cannot be pressed into service vis-a-vis the right of the accused accruing under section 437(6) of the code.